Do dissents really matter? Let's talk about that. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Dissenting opinions in judicial decisions serve several important purposes, and they can have significant impacts on future legal developments. A dissent provides a platform for judges or justices who disagree with the majority opinion, and it allows them to express their differing views on a case. It allows them to articulate their reasoning, both their factual reasoning and their legal reasoning, and the principles they believe that have been overlooked or misapplied in the original opinion. Dissents offer alternate legal interpretations, and they preserve those in writing so that they might wind up being adopted in some future case by some future court. By presenting a counter argument, dissents can stimulate broader legal and public debate on important issues, encouraging reconsideration and dialogue. Dissents can serve as a signal to future courts about potential issues with the majority's reasoning, providing a foundation for reevaluating the opinion if societal values or legal interpretations shift. Dissents can influence future legal thinking and academic discussion, shaping how laws are interpreted and developed over time. Now, dissents lack precedential force. In other words, you are not going to be able to convince a court to apply the dissent in a case because it doesn't have the force of law. But they're often still cited primarily as additional support for certain arguments, not so much because they have any precedential value, but because when a Supreme Court judge or a Court of Appeals judge makes an argument in writing that supports your case, it's nice to have his little blurb in there in your brief because it shows that you're not the only one who is reasoning that way. And for this reason, the dissents can become influential if a future court finds the dissenting reasoning more persuasive or appropriate in a changed legal or social context. Now, Congress and legislatures may also pay attention to dissents. They may consider these opinions when crafting or amending laws, as they highlight potential issues or areas where statutory clarification is needed. When a dissent is written at the state level or the circuit level in federal courts, that dissent is often picked up and adopted in arguments raised at the Supreme Court. In one case I know of, the judge at the state Supreme Court railed against what he believed was a ridiculous ruling by the majority in that case. He was the only dissenter in that case. It was a 6-1 opinion at the state Supreme Court. Because it involved a constitutional issue, though, it went to the Supreme Court of the United States, and his dissent, although it wasn't adopted verbatim, was nevertheless used by the Supreme Court in its 9-0 ruling. So he lost 6-1 at the lower court, and he won 9-0 at the Supreme Court. Not that the judge wins in either way, but it was nice to see that his opinion had some force when it went up to the Supreme Court. Now, some dissenting opinions gain recognition over time and become part of a justice's judicial legacy, often cited in later cases as a visionary perspective that anticipated future legal developments. Justice Harlan's dissent in Plessy versus Ferguson is a good example. Plessy versus Ferguson, as you probably all know, or at least as we've discussed on the channel here, is a case that said segregation in education was just fine as long as the segregated schools were separate but equal. Even then, that statement sounded like an oxymoron because how could separation of the races in schools ever really be equal? But in 1896, the Supreme Court endorsed that nonsense. Justice Harlan's dissent argued against the constitutionality of racial segregation, and although it did not prevail at the time, it laid the groundwork for the arguments used in Brown versus Board of Education to overturn segregation of public schools. And Justice Antonin Scalia's dissents are also epic. Known for his strong and often colorful dissents, Scalia's opinions frequently influenced legal thought and provided a basis for future legal arguments, even when he was in the minority. As I was getting ready to graduate from law school, Justice Scalia came to St. Louis University School of Law to do a presentation on the Supreme Court. And I went there and I listened to the whole thing. He was very articulate and he's a really good speaker. I enjoyed being there for the argument. And what was funny to me about it was that one of the professors, who happened to be a priest, challenged him on the issue of specifically this Brown versus Board of Education. And he said, "Oh, now you're not going to beat me up with the bloody shirt of Plessy versus Ferguson, are you?" I thought that was pretty funny. But one of my peers in the school thought very, very highly of Judge Scalia. And he brought a brand new baseball, a big Spalding baseball, and he asked the judge to sign the baseball. And Scalia looked at him a little funny and said, "Huh? You want me to sign a baseball?" And he said, "Yeah." He said, "You're one of the few hardball pitchers on the Supreme Court." Justice Scalia signed the baseball for him. But to understand the real value of dissents, you have to understand how courts work. In a case without a ticking time bomb in it, the case is usually decided at conference. Judges vote, whoever is tasked with writing the opinion will, in a few days, start circulating drafts to other chambers. Once a first draft takes shape, other judges chime in and suggest changes, additions, or deletions from the text, while at the same time, those who are not in the majority begin writing the dissent. The dissent takes aim at the legal reasoning and often mocks it openly, essentially calling out the majority for their dismissal of legal arguments or their refusal to adopt specific authorities, or to basically poke holes in their legal reasoning, pointing out why those cases don't stand for the proposition that the court or the judge is advocating in that particular instance. What happens then is at the next conference, after the case is held over, dissent is discussed among the judges, and sometimes votes change, and sometimes that dissent becomes the principal opinion in the case. My favorite reasoning for championing dissents is that they illustrate when judges depart from their established legal reasoning to reach a result, and what the judges who dissent, what do they really care about? Those dissents make it easier to predict which judges might be more susceptible to certain legal arguments. It shows, in essence, what they care about, and it demonstrates their principles. So that's the 411 on dissents and how they're used and what they mean in both state and federal courts. You usually see them in cases that matter. When it's just two people quarreling over something like a divorce and there's no important legal issue at rest, in that situation, they don't really get into writing dissents. They may disagree with the outcome, but it probably isn't worth spilling ink over that when the opinion is not setting precedent that will become important later on. I hope this explanation helps people understand a little bit better about dissents. Thanks again for watching. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.